I think it's probably still one of the most common misconceptions is this notion among some organisations that privacy is a bolt-on at the end. And we see this quite a lot across different areas of our work. But for instance, I have noticed a change in the sense that DPIAs now tend to be much better than they were. They sort of tend to be quite detailed, reasonably well thought through. But I do notice that typically a lot of the thinking on those has been done by the privacy lawyers and the DPOs, and not kind of cascaded down and not maybe thought about by the people in the organisations who are designing services or designing products. And so I still think there's some way to go in terms of just getting the message out that people think about privacy early on in the process. And the ACO has produced guidance on this. So as part of our engagement on the DRCF, one of the projects that we worked on was about design. And we have produced some guidance, which is kind of tied into this notion around to sort of supplement our privacy by design guidance, but it's really about privacy in the product design life cycle. So it's meant to be a little bit more tailored and a bit more specific to organisations that are actually developing tech, really, but it can be adapted to any organisation. And I think it's just intended to flag issues to people at different stages of the process. So some topics that it looks at are things like, some of the things you mentioned, like sort of communicating the value of privacy in your business case, highlighting how privacy enhancing tech can lead to an advantage. And we just heard from one of my colleagues, Clara, about privacy enhancing tech earlier. And then on the more sort of substantive legal side, the guidance looks at things like, how to get consent interfaces right so that you actually get unambiguous, valid consent, which I think again is something that does tie organisations up a bit when the message gets mixed up between the legal advice and sometimes the designers, and things like defining the minimum amount of personal data that you require. So it's quite a helpful tool for anyone thinking about that. I think another misconception that we still come across a bit is the notion that smaller organisations don't have the same kind of data protection obligations as larger ones. And I think, having advised charities and stuff in the past, often, or in some cases, some of the small organisations have very vulnerable, beneficiaries that perhaps operate in the health sphere, have the most sensitive data and the greatest need to comply with data protection law. So I think that's a misconception that still exists, and the ACO has done a lot of work to try and bridge that gap, and we have a new sort of dedicated resource for SMEs, which is I think it's called the SME Hub on our website, where we have produced lots of different guidance aimed at smaller organisations to help them. So things like, how do you drop a privacy notice? How do you report a breach? And I think that is an important part of our kind of objectives, our sort of strategic objectives, is to reach organisations and help them to understand what their obligations are.